got the ruling that came out from the Superior Court judge in Fulton County dismissing 6 counts in the state of Georgia versus Donald Trump. Now, these counts involve the solicitation of officials to violate their oath of office. But Jordan raised a very interesting point. I think, Jordan, restate that for people, because it is interesting that is there a tell here about what's going to happen on this FANI Willis being removed from the case?
Yeah, we left for this trip to go back to visit the ECLJ. We were in Paris first for meetings last Wednesday. And that was after the hearings had been done, and the judge said he was going to take his time to issue the ruling on whether or not FANI Willis and her whole DA team would be dismissed from the case and a new DA team appointed. And then you get these breaking news alerts, even while we're over here in France, and we're following everything like the hearing yesterday, about the judge dismissing some counts, but also writing a path forward for the DA to rebring the counts, going even saying a quick way could be to go before a grand jury. Of course, there could be appeals. That would take longer. But then it's whether or not to read into anything there. Because as Andy said, in a normal case, because you wouldn't have the challenge of the DA being dismissed out there, why is the judge ruling on this if he actually really is considering dismissing FANI Willis and the entire DA team?
They can either ask for a certificate of immediate review to the Court of Appeals. Unlikely they would do that. The judge said he would grant that and let them appeal it right away if they wanted to. But the easy way to do it is what the judge suggested. Go back to a grand jury in Fulton County and clean up what you failed to do, and that is to plead the evidence with a little bit more particularity in each of your counts, saying that this is the nature of the commission, saying what the underlying felony is, that they supposedly were importuning the members of the General Assembly or the Secretary of State or the members of the House to do. Clean it up a little bit, give me a bill of particulars, which in federal court would happen, and clean it up.
FANI Willis got it wrong when she went to the grand jury.
Yes.
She didn't get it pled, and she didn't plead the indictment with specific allegations meriting a crime.
That's right.
So I think that part's important. Sloppy.
It was work that should not have occurred. A DA's office in Fulton County should never have failed to plead with particularity a motion, a count of an indictment, especially in a case of this nature. If someone did not do their legal research, someone put it together fast and loose and didn't do it right, the judge caught it and said you're going to do it right or not do it at all.
They're likely not going to appeal here because that would take forever. And they can impanel a grand jury, probably impanel now. There's always grand juries sitting, and they can go back to the grand jury. We'll see what happens there. And we'll discuss it. Of course, everybody's waiting for the big decision, which is, will FANI Willis and the Fulton County DA be thrown off the case? Jordan, we're here. Now, you're in France at our office at the ECLJ in Strasbourg. We're hearing that order is going to come either tomorrow or Friday.
Well, that's what I was going to ask. I mean, it's kind of bizarre. I remember sitting there with both of you last week before we were here in France, which I've now been here a week, and we still don't have that order from the Fulton County judge. And then we get this breaking news about these counts that can be repled. So should people read into anything there? Should they read into the fact that he's already telling the DA's office that they can, replead these counts, go before a grand jury again, as if they aren't going to be removed?
Normally, it would not mean anything regarding other than to go back to a grand jury. But what's interesting here, and we'll talk about this coming in this next segment, is what you just raised, which is, did she get it pled right, and what does that mean for her being thrown out?
This is really important, I think, to look at this. This does not mean the entire indictment is dismissed. The state may also seek a re-indictment supplementing these 6 counts, something easily remedied. So he says, I am dismissing these counts because they didn't plead the underlying felony with particularity, but no problem. You can re-indict it and supplement those counts, easy remedy. So, the judge giveth and the judge taketh away.
A majority of Democrats would back efforts by lawmakers to stop President Trump from entering the White House by blocking his congressional certification of victory. Now, everybody else called that, this is what's so interesting, everybody else called that interference with Congress, but I guess when Democrats do it, it's not. In a poll that suggests a Democratic-style January 6th protest, the latest Rasmussen report survey found that 57% of Democrats would support, quote, refusing to certify the election results if Trump wins, Andy.
When Trump does it, it's insurrection. When the Democrats do it, it's promoting democracy, and it's okay to do it. That's exactly what this is.
We talked to you about the Fulton County case, 6 charges dismissed. We'll see what the judge decides on keeping FANI Willis in the case or not. We should know that tomorrow or Friday. I want to give you an update, though, on a case that we filed at the American Center for Law and Justice. We represent a group of students who have been told they could not pray at a school sporting event. And, in fact, the coach said, don't let me see you do that again. Now, the school district came back and said, well, we'll allow and the coach called it a moment of, a half a second moment of reflection. Totally violating the students' free speech rights, Andy.
It's as if that we're living in a different century, but I was looking at some of the cases that we cited, Jay. We go back to Tinker versus Des Moines School District, 1969 case, Widmar v. Vincent, 1981. This is not new law that we are alleging was violated. This is old, established Supreme Court precedent that prayer does not stop. You don't lose your religious rights at the schoolhouse gate. And here we have, in the year 2024, a coach threatening a child for doing the terrible thing of student-initiated prayer.
In the Santa Fe case that we argued, Justice Stevens in the opinion wrote that students have the right to pray before, after, and during the school day. You can't have the school doing it, but students can do it. And that's what was happening here. But don't let me catch you. I said that. Don't let me catch you doing that again, or you're going to do what? The track and field coach. You're not going to let them race?
Right.
I mean, not going to let them participate in the sport. So they sort of tentatively agreed to what I call ceasefire, where they said, we talked to the coach, and then the coach sent out an email saying, do whatever you want, or do it wherever you want, but I'm talking about a moment of reflection. And he already defined moments of reflection by a half a second. So we're in federal court on that. We're in federal court in Nevada for the student that was required to read the pornographic monologue, I guess is the best way to say that. I mean, it's absolutely horrific. And then you go back to, as I said, then you go from representing students in these cases to Jordan was just on coming out of the European Center for Law and Justice to then these huge constitutional cases. We won the 14th Amendment challenge to try to keep Trump off the ballot, which would have been, forget whether it's Donald Trump or not. The idea that a state could remove a presidential candidate was absurd. And all 9 justices agreed, by the way. But it's interesting. We filed a separate appeal for Colorado in that case. That is in conference on Friday. Now, I expect what the court's going to do is grant the certiorari petition, vacate the lower court opinion, remand it back to the trial court and say, you better comply with what we said in the other Supreme Court case. So for us, if that happens, it'll be a double win. But it just shows you the lengths they're going to. And then you got the whole all those Jack Smith cases, Andy, including the January 6th case, and they've got some real hurdles in that one.
Right now, the immunity case is going to be a presidential immunity, absolute, limited, whatever.
I think it's going to be limited, but I think they're going to say there's limited presidential immunity, the limitation being asked to be for official acts.
Official acts, and then probably will remand it to Judge Chutkan in the district court in Washington, D.C. to determine.
Is there any way at that point, if that happens, Andy, which is what you and I predict,
yeah.
Is there any way at that point, you've done a lot of criminal trials in federal court, that they could get that into trial before the election?
No.
Because you got a bunch of motions you have to file.
Yes, it's not going to go to trial before the election, and if Trump wins after the election, it's going to be dismissed by the Justice Department, and we won't have a case.
If the Willis order comes out late Friday, we'll be prepared to go live again, and if we get the GVR order, I'm talking to our producer, if we get the GVR or a grant, vacate, and remand order from the Supreme Court, we probably would go on that too. So we'll keep you posted on that.